Hello, everyone. For folks joining, we'll give it about 30 seconds and then we'll get started. Good morning, everyone. Welcome to the Environmental Law Institute's webinar, U.S. Authorities and Considerations for the Global Plastics Agreement. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at ELI. We're so excited to see you here today. This webinar is a follow-up to the recent report published by ELI and the Monterey Bay Aquarium on existing legal authorities the U.S. federal government can leverage to achieve the national goal of addressing plastic pollution while safeguarding human health and the environment. We also had a previous webinar on the topic that was transcribed for the Environmental Law Reporter. We'll post the links to the previous webinar and to the transcript from that webinar in the chat if you would like to check them out, although they are also on the webpage for this event today. Today's event will be recorded and posted to the ELI website within a few business days of the program. So if you're unable to view the entire webinar, be sure to check back to that event webpage to see the recording. We will also be saving time for audience questions at the end of the program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. There's no need to wait until the end of the program to pose your questions. While the chat will be open throughout the webinar for you to post any observations or chat with other attendees, please put any questions that you wish for our speakers to address in the Q&A box. We will not be tracking any questions that come in through the chat. I'll now go ahead and turn things over to our wonderful moderator, Cecilia Diedrich. Cecilia is a staff attorney here at ELI, as well as the lead of ELI's Plastics and Toxics Initiative. Cecilia, I'll turn things over to you. Thank you all so much for being here.
Thank you, Madison. Good morning, everyone. And as Madison said, I'm Cecilia Diedrich. I just wanted to thank you all so much for joining ELI and the Monterey Bay Aquarium for part 2 of our webinar series on U.S. authorities to address plastic pollution. Our first webinar, as Madison mentioned, focused on both plastic pollution and related PFAS issues and built upon our report, Existing U.S. Federal Authorities to Address Plastic Pollution, which surveys how existing U.S. federal laws may be applied to plastics. I wanted to note that today we published an update to the first report, as well as a summary of the substantive changes, links to which I'll post in the chat, and to the event webpage. We've also published a companion report on U.S. authorities and considerations for the Global Plastics Treaty, which brings us to today's webinar. We want to welcome feedback on that report and expect to incorporate additions from today's discussions. Today, we have an excellent panel gathered to discuss the Global Plastics Agreement negotiations, U.S. authorities to engage in and sign onto international agreements, and considerations for the U.S. as we head into the 5th and potentially final round of negotiations for the Global Plastics Agreement. Presentations, as Madison said, will be followed by a Q&A discussion. And as she mentioned, please just make sure to post your questions in the Q&A box and not the group chat. First, we'll hear from Margaret Spring, Chief Conservation and Science Officer of the Monterey Bay Aquarium, ELI board member, and chair of the ISC expert group on the plastic pollution to the Global Plastics Agreement. She will begin the discussion by providing context on the current status of the negotiations. She'll be followed by Dr. Alexandra Harrington, lecturer in law at Lancaster University Law School and chair of the IUCN WCEL Agreement on Plastic Pollution Task Force. She will discuss the background on the international legally binding instrument and paths to move forward in this process. Then we'll hear from David Wirth, a professor and Dean's Distinguished Scholar at Boston College Law School, where he served as the Director of International Programs. He will discuss the U.S. engagement in the treaty-making process. And last, but certainly not least, we will hear from Dr. Jamala Jin, Science and Policy Advisor for the Break Free from Plastic Coalition. She will discuss the stakes of the U.S. at home and abroad. And with no further ado, I'd like to hand it over to Margaret.
Morning, everyone. Happy to be here today and just to have a quick 5-minute overview of a very complex topic. We're really happy to be here with this tremendous panel of experts. And our conversation today will explore the linkage between U.S. authorities to address plastic pollution and considerations for the Global Plastics Agreement. And of course, there's a lot going on. This is a very dynamic time, and we're, of course, fully aware of the election coming next week in the United States. And yet, the timing for the International Negotiating Committee session in November is not changing, and it's coming upon us very quickly. So let's go to the next slide. So where are we? Well, we're at the we're heading into the fifth and final meeting of this agreement negotiations. For ease of reference, I'm calling this the Global Plastic Treaty or Global Plastic Agreement. There's a very long-winded term, ILBI. You'll hear that from Alex, our next speaker, so just know that it's the same thing. I've been at all of these meetings. I represent the International Science Council as well as the Monterey Bay Aquarium, and this has been probably one of the fastest, most complex, and most urgent topics we've been tackling at a global level, with the increase in production and just skyrocketing, and the modeling has been showing us that there's no time to waste. And so this has been a 2-year process laid out for us to get to a final text. The first meeting was quite an exploratory moment, and I'll go through what happened at each meeting briefly. But where we are right now is going into this fifth meeting. Coming out of the last meeting in Canada, we actually had a 77-page compiled text, which was quite unwieldy, almost all bracketed. And so there's a lot of discussion now led by the chair from Ecuador, Ambassador Luis Valles Valdivieso, to see if we can get to a negotiating position where we can use the time efficiently in Korea, in Busan, Korea. Well, some breaking news is right in the middle of the night, the chair issued a third non-paper. He calls them non-papers, but his assessment of where we are. I won't have had time to review it, but those elements are interesting and very important for us to all be paying attention to and going into the meeting. That, of course, is 17 pages, which is far shorter than the 77 pages. And so we look forward to finding ways of organizing. Go to the next slide, please. So this is really a negotiation among member states, and there are sort of three groups or non-groups in some cases are organized with different positions on the treaty. However, and so just to know that while the member states are leading this process, there's a huge engagement of the civil society and the international governmental organizations as well as UN. So at the last meeting, we had 158 member states, 47 UN organizations, 6 international governmental organizations, and 617 organizations representing civil society among NGOs, scientists, of which I lead a group, and then industry. So huge number of players making this even more complex. And there's a really strong support from many member states, scientists, advocates, and indigenous tribes and nations that say we need to reduce the production of plastic and reduce or eliminate toxic chemicals and products of concerns, and shift the burden that's been placed on individuals and communities. This involves having arrangements, polluter pays or extended producer responsibility, dealing with waste generation and legacy waste. And so the elements that are under consideration are vast, and you'll see that in the text and in the conversations from Alex. I will say one of those member states is the United States, which is one we've been paying attention to. Of course, the position of the United States is very much under scrutiny as we go into this meeting. And the United States has really made a lot of changes in the last year or so. They just started to shift their direction in line with many of the authorities we had identified in the report that we came out with in March, which is great. And on July 19th, the Biden-Harris administration released the first comprehensive government-wide strategy to target plastic pollution at all stages of the life cycle, which is what is intended to happen in this treaty. And so that was influenced also by the National Academy's study on this question, which Congress asked for, and I chaired the committee that issued the recommendations, was to create such a strategy, which I think has helped align the United States and put it in a strong position to be influential in this treaty process. And at the same time, they announced a goal to phase out federal procurement of single-use plastics from food service operations, events, and packaging by 2027, and from all federal operations by 2025. And that was something that a number of us, including some of the aquariums we work with, have done. So that's sort of where the U.S. has been in the domestic side. And I'll go to the next slide to sort of talk to you about where we have been. Just to say, the first meeting was very early stage. We really didn't get to a zero draft until the third meeting in Kenya. So that's late in the process, I would say, and Alex can confirm that. And in Canada, there was a lot of discussion about this zero draft, and that was streamlined into a much longer draft. And then there was intersessional work, and Alex, again, will go over this in her presentation. And so what has now happened is there have been a number of high-level conversations among the delegations and the chair, which are starting to clarify some of the positions. I will say that key elements of this treaty are to look at what's the goal. Human health and the environment is seen by many as the critical goal to make sure we're hitting. Human health came into this discussion late, but it's incredibly important. Production and design is very top of mind. Chemicals and products of concerns, how do we deal with them? Waste management and legacy issues, financing, process, compliance, monitoring, and plans of action are all part of this very complex treaty. So you can see that we're in a race against time. Next slide. Go back. Yeah. And so one of the things that I want to remark on is that at UN Climate Week in September, Undersecretary Fernandez of the State Department gave a very clear statement of where the United States was with respect to a number of these issues that were critical to many of the groups who are watching this process. One is that he confirmed that they would support leveraging demand and supply side measures, which was helpful, that they would support a global goal to reduce global production as a North Star, just to have and what that means is still under discussion. And then understanding that global criterion lists for chemicals and products of concern would be useful. And all those questions were really not as clear. And so that was helpful going into this meeting to see that. And so you'll see the US evolving and getting clearer in their positioning as we go forward. And I'm hopeful that the information provided today and the update of the report is going to be and continuing to be helpful for that. Next. So as I said, the chair is having an incredible number of meetings to align on the process and the text. He has just had a third non-paper, which I mentioned, come out. These non-papers were his synthesis of where he thought there would be some alignment among the parties so they could start and have a process to go forward that would be more orderly with only 7 days to go. And so, as I said in the slide, Chair's revised text early November. Well, we beat the clock. It was last night. And so we look forward to reading that and seeing how we can move things forward. There's a lot it's important that the chair has been doing this work. It really gives us hope that there could be a strong treaty, but a number of groups are still going to be weighing in, as you'll hear, on what this is going to look like. And it's not a treaty text. It's areas where he's suggesting text or suggesting there needs to be more discussion. So that's where we are. Next slide. And so where are we going? I said the 7 negotiating days in the treaty process, which the chair has outlined a process ahead. And just to note that while when we close down this meeting on December 1st, the negotiating meeting, and hopefully have a text, there's still work ahead. There's a diplomatic conference at plenipotentiary sometimes next week. Excuse me, next year. It's not that fast. And then there'll be a lot of work to be done before a conference of the parties, and Alex Harrington will get into that too. So I want to thank ELI for hosting this, and and to the panelists. And I'm going to turn now to Dr. Harrington.
Thanks very much, Margaret. I will jump in, I guess, and thank you, and thank you for setting up everything so well. And welcome everyone to today's event, wherever you are, if it's morning or afternoon or evening. So as Margaret mentioned, we all tend to call this the Global Plastics Treaty, or the Plastics Treaty, for a number of reasons, including brevity and it being far easier than the official name, which is the ILBI, or the International Legally Binding Instrument on Plastic Pollution, including in the marine environment, which is what was actually the authorized language used in the UNEA resolution. So this topic will be kind of the overarching theme for my presentation. But if I do use the Plastics Treaty nomenclature, please do forgive me. It is just a lot easier to talk about. Next slide, please. Thank you. So Margaret gave a lot of this information already, but just to kind of reiterate a few things. The idea of regulating plastic pollution at the international level is not necessarily new. It's been discussed for a while. However, what we finally saw in early 2022, when the UN Environment Assembly had its continued, so its second UNEA Assembly 5, which was obviously perhaps, which seemed obviously or unnecessarily to explain, but was continued because of COVID. We had Resolution 514 adopted, and Resolution 514 gave us the mandate for the creation of an intergovernmental negotiating committee, also known as an INC, to have a series of negotiation sessions and meetings with the idea of creating the ILBI. Now, the parameters for this were quite ambitious. They still are considered quite ambitious, in that the ambition was, and still is, to have the treaty concluded by 2024, by the end of 2024. And we were authorized to have 5 different rounds of negotiations, which we're now talking about 7 days of negotiation. In the beginning, it was really 5, and then we've kind of expanded to 7 days, which might seem like a lot when we think about it in the immediate terms, but in the abstract is not a great deal of time when we're trying to negotiate a treaty. And if you move to the next slide, please. Thank you. This, again, to reiterate some of Margaret's far more artistically designed and expressive way of showing this, but this is the timeline. And to highlight kind of what happened, how this process has worked, how we have gotten into the point of having, as I have now on my desk, multiple different iterations of drafts, etc., to look at. We got into this very quickly, and so the work began quite quickly after the UNEA resolution was passed, after the Resolution 514 was adopted. And the first INC meeting happened at the end of 2022 in November in Punta del Este in Uruguay. What was interesting there was that this was very much an opening meeting. And I often go back and reflect on kind of where we've come or how far we've come in such a short time. And this is where we really first saw the information gathering, the idea gathering happening, where there were exchanges from a number of different countries about what was important to them, why plastic pollution was an issue, and actually to kind of highlight one of Margaret's points. What we heard there early on, and this was surprising to many, although perhaps it shouldn't have been coming out of COVID so closely, was the stress on this being not only an environmental treaty, but also a human health-based treaty, and the need for this from a human health perspective. There was no set text per se to negotiate. This was very much information gathering. And it also was the first spot where we really saw the inclusion or efforts to include stakeholders in this process. And stakeholders, so intergovernmental organizations, non-governmental organizations, et cetera, have been very much at the forefront of a lot of the efforts in the INC process, providing especially very important scientific and policy analysis. So we saw that early on. By the time we got to the second INC in Paris, we got a bit stuck. Some of you will remember, if you were involved in this, we got a bit stuck in a lot of procedural aspects. So the 5 days of negotiations that we had didn't necessarily go as planned. But what we had coming out of that was a much better understanding of what areas would possibly be included in a treaty, what areas were important to states, and from the contact groups. So when we do negotiations, we all don't just sit in the same room together, but we also break out into some smaller groups that we call contact groups, where we have different assignments, so different topic areas or different subject matter questions posed, and then those are discussed more concretely and more narrowly, and those results of those discussions are then reported back to the larger plenary. So we saw a number of contact groups meet in Paris and generate information and reports, which was then used for what we termed the zero draft negotiating text. So the first effort to have a draft of what the treaty might look like, which was used as the basis for negotiations at INC3 last November in Nairobi in Kenya. That was then updated, and so the idea was text that was proposed during INC3 would be included in the actual next negotiating text, which was termed the revised zero draft and was used as the basis for negotiations in Ottawa during INC4 in April. What we have seen, and I will just kind of get ahead of myself for a second to finish this chronology of the negotiating text. What we have seen coming out of INC4 was a mandate for the chair and for the secretariat to create a compilation document, which would reflect all of the additional textual proposals, and including things like striking or removal of text or not including text, and have that as the basis of the negotiations for INC5. Now, as Margaret referenced, the ultimate compilation document itself, when it was revealed, was 77 pages. Thus, there has been this effort by the chair to winnow it down a bit, and we'll get there momentarily. But just to swing back to the timeline, in August of 2024, there was an intersessional meeting held in Bangkok. And this was also authorized by the INC itself at the end of the Ottawa INC4 meeting. And there were two areas of focus. One group focused on financing, so financial mechanisms, other alternative avenues of financing, capacity building, technology transfer, et cetera. And the other focused on what were termed to be criteria and non-criteria approaches for plastic production, plastic product design, and chemicals of concern in plastics. Now, the outcome of these two entities was a set of reports, one for each, that reflected the discussions which took place. We could have a whole webinar just on that alone, but we certainly will not. And just to note that these reports are now available on the website for INC5. They are not legally binding. They are reports. They will be presented to the plenary, the opening plenary, so the group of all of the members of the INC together, and any points that are contained in them can be discussed in Busan. They can be used as grounds for perhaps arguments or negotiating text proposals, but they do not have any actual negotiating text weight on their own, the way that the zero draft or the revised zero draft or the compilation document does. Next slide, please. Thank you. Now, we will be in Busan. Many of us will be, and if you will be and you're in the audience, please, let us know. We would be happy to chat. Certainly from the 25th of November to the 1st of December. Some of us kind of cynically remember that INC4 went over into the next morning, so perhaps it will be the 2nd of December. We will see. And what we know now is that the negotiations will be based on the compilation document. They also will be able to take into account the reports that are received from the expert groups and also the white paper. And the white paper, which Margaret, sorry, not white paper, the non-paper, which Margaret mentioned, has just been released or will be released by the end of the day today on the website officially, is a proposal from the chair. And it should be pointed out, because there will be a number of discussions, that the only authorized by the INC authorized document for negotiations is in fact the compilation document. The non-paper is a paper that is being offered by the chair as a means to try to address some of the issues that have been raised, and also to try to address some areas where he sees the potential for convergence to have a forward progression at INC 5. However, it needs to be proposed, and it needs to be approved by the INC members themselves to be used as any form of negotiating text at the INC. And I have it on my desk. I'm looking at it now, and there are a number of things that may potentially be quite controversial. So we will see how this progresses. But that is the full suite of those 4 documents that will be available in some capacity for negotiations during INC 5. Next slide, please. Let's run through these quickly. So no matter what we're looking at, whether we're looking at this large document, whether we're looking at the smaller document, no matter what we're looking at, the ILBI will very much be created out of Busan and whatever follows on from Busan. And it also will be very much created in the future at the conferences of the parties, especially through the use of annexes, as well as the use of potential smaller groups, creation of subsidiary bodies, etc. So often, I think it's important for us to remember that the Plastics Treaty, or the ILBI itself, will be the first step in an international effort to regulate plastic pollution. But it is envisioned, even in the non-paper, it is quite clearly envisioned that many of these issues will not be able to be addressed in the treaty itself. And so we will need to think about how to draft a treaty that is wide enough to address them, these types of issues, and to make sure that they are at the core of our process moving forward, but at the same time, that we're able to get a treaty text agreed upon, hopefully within the ambitious timeline we have been presented with by UNEA Resolution 514. Next slide, please. And just a few things to highlight what to expect as we're going into Busan. The chair's scenario note, which has already been available for about a week, so I'm sure some of you will be familiar with it, envisions that we will have, as is standard, the plenary meeting, but we will also then have 4 different contact groups and also a legal drafting group. And the contact groups that have been proposed by the chair focus quite cleanly. You can kind of separate them out into 2 that would correlate to the expert groups that met in Bangkok and that focused on the criteria and non-criteria issues. So more of the scientific and technical aspects, such as plastic products, chemicals of concern, etc., and also waste management. And then 2 that focus on the financing and means of implementation aspects of the potential ILBI terms. Many of you will wonder how these will meet and what the schedule will be. I don't quite know exactly. There has been a trend to only, where possible, have 2 of these groups meet at the same time, so that we can have smaller delegations be able to participate meaningfully in both, and not have a situation where a delegation of perhaps 2 people or 3 people is unable to meaningfully participate in all of these aspects. Next slide, please. Thank you. There also, I should point out, is a very interesting idea of having a legal drafting group. And so the legal drafting group will meet as convened, and it will clean text. So it will help to try to speed the process along in terms of having a clean and legally appropriate text that could be presented both at the end of INC 5 and also at the diplomatic conference, which we are envisioning next year, hopefully in 2025, and we are assuming will happen to allow the official signing process to start for the treaty and then we would get underway for the ratification process. And the ratification process itself will be determinative of when the next COP is or when the first COP is. But we're also assuming that there will be intersessional work between the diplomatic conference and the first COP, which likely wouldn't meet for several years, depending on the number of states that are needed to ratify the plastics treaty. So that is a very kind of nutshell version of what is going on, and what some possible outcome scenarios might be for INC5. If you have any other questions, obviously we're here and we're happy to take them. So I will now pass the control back over. Thank you.
All right, shall I go ahead and introduce myself? I'm David Worth. I think I was already introduced as at the beginning. I'm a professor at Boston College Law School. I have a great deal of experience in these multilateral negotiations. I'm also a member of the Minderoo-Monaco Commission, along with Margaret Spring and others, which is the major report in the Annals of Global Health that drew particular attention to the health problems of plastics. So I've also had the good fortune to attend the two previous rounds of negotiations in Paris and in Ottawa, and I am planning on going to Busan. The organizers have asked me to focus specifically on the treaty making process here in the United States. So the previous speakers have focused on the multilateral process. I've been asked to focus on the treaty making process here in the United States because it's rather unusual, not unusual, but not necessarily terribly familiar to many participants, to many students, and even to some practitioners. And also because there are, as you will see, some very important junctures that could very well affect the outcome of this process. So it's not because of lack of multilateral perspective. I love participating in multilateral processes, but just for now, we're talking about here within these United States. So could the slide be advanced, please? My machine does not seem to be working. Okay, so Dr. Harrington referred to, and other speakers referred to, UNEA Resolution 514 from March 22, which is our basically our outline, our marching orders, our remit, our mandate. This comes from the United Nations to the INC. The INC consisting of basically all members of the United Nations Environment Program. That was too fast. All members of the United Nations Environment Program, which basically include all states on the planet, something on the order of 193 of them. So this is basically the outline, the first cut that the UN agreed to delegate to the INC to negotiate in greater detail. So it includes, as you will see, differentiation, flexibility, taking into account national circumstances. This is a very common component of multilateral negotiations these days, particularly dating from the Paris Agreement of a year ago, and also roles for all stakeholders, including the private sector. Interestingly, as well, a component addressing a just transition. So here you have the view of at least one stakeholder, which is expressing its right to free speech on the streets in Ottawa, outside the formal negotiation. But part of the mandate is to include all stakeholders. So getting back to the United States, there is an important question that is still unresolved at this point. That is what a foreign relations lawyer such as myself and foreign relations lawyers such as you will be at the end of this presentation. You will be initiated to the high priesthood of those who actually understand these issues. Is called the choice of instrument. It turns out that there are, in fact, there is not just one choice of instrument. The previous speakers referred to the treaty, which is correct on the international level, but within the United States, it's a little bit more complicated. The U.S. is what's called a modified dualist legal system. We inherited this from our British legal forebears, and it is coupled to the supremacy of Parliament. The basic principle being that no law in the United Kingdom takes effect without an act of Parliament. So that it is Parliament that is responsible for coordinating domestic law within the United Kingdom and international law of the sort that was described by the previous speakers. We inherited this. It's slightly changed in this country, but basically that's the issue. There is a need for governmental action as a mechanism to coordinate the domestic legal regime, that is the report that ELI prepared, and the international obligations that the United States would be prepared to take on in the new agreement. All of you are students of the Constitution, and you know that the United States makes, which is the technical term, makes treaties by and with the advice and consent of the Senate by a 2/3 majority. Here's point number one into the initiation into the high priesthood. The Senate does not ratify treaties. The president ratifies treaties. Only the president can ratify treaties, but the Senate must give its advice and consent by a 2/3 majority. There are many, many agreements that are sitting up in the Senate right now, awaiting Senate advice and consent to ratification, including the 1982 Montego Bay Convention on the Law of the Sea, a variety of others that have not entered into force due to the absence of Senate action. And a 2/3 majority, what the Europeans would call a qualified majority, is actually quite a reasonably high bar that was intended purposely by the framers. So it turns out that the number of treaties that are done, the number of binding international agreements, to get back to Dr. Harrington's terminology, the number of binding international agreements that are the law as a matter of public international law done that way are actually fairly few. Fewer than 10% of the binding international agreements of the United States were entered into through that process. Well, how can that be, you might ask? Because that's what the framers told us. That's what the Constitution says. And the answer is that there are actually two kinds of binding agreements. The first, I just mentioned, which is in Article 2 of the Constitution, Section 2 treaties that require Senate advice and consent by a 2/3 majority and subsequent ratification by the president. The other category is called executive agreements. And just to be clear, this is a strictly US term. There's only one other country that has this term that I know of. That's the Philippines, which inherited a part of its legal system from the United States for obvious reasons. Executive agreements, they are just as binding. There's no such thing as a degree of binding character. They are equally binding as Article 2, Section 2 treaties, but they find for their legal authority different sources of domestic law within the United States. So when the Senate gives its advice and consent by a 2/3 majority, that is the legal authority domestically to bring the agreement into force, or to bring the agreement, to make the agreement effective within the United States legal system. Otherwise, there are alternative options. The president, of course, is not a dictator. The president is not a king. We got rid of George III and replaced the British monarchy with a president who is a creature of law. So the president, these executive agreements must find some alternative legal authority, one being the president's plenary powers. I'll describe this in just a little bit further, but the president is the commander-in-chief. Under the Constitution, the president is the chief executive of the government, and most importantly for these purposes, the president is the diplomat-in-chief. He's the boss of all diplomats all over the world. He is the boss of all of the negotiators that will be going to Busan. They ultimately all report to him. The Secretary of State, the somewhat unusually named Foreign Minister of the United States, is and by the way, thank you for the comment, he or she. The president, he or she is the, so thank you for the comment. The president's also the diplomat in chief and carries on all foreign negotiations for the United States. Secondly, another source of law for the president is a statute. This is the importance of the ELI report, because that compendium basically can provide the legal authority for an alternative to an Article 2, Section 2 treaty, and that would be ratified by the president after previous Senate advice and consent to ratification. All of those statutes, the Clean Water Act, the Toxic Substances Act, all of the domestic environmental statutes that we're familiar with can provide domestic legal support. And another would be another Article 2, Section 2 treaty that has already received Senate advice and consent to ratification. That's not this situation, but it could be, for instance, the Paris Agreement, which is a subsidiary agreement to the UNFCCC, the UN Framework Convention on Climate Change. Now, this big red dot in the middle is what's called the choice of instrument juncture. That is coming up. This is done in secret. It is done quietly. It is not done with any degree of transparency through a process known as Circular 175. A lawyer in the State Department prepares a memo basically matching up the legal authorities, including those that are included in the ELI report, and asking the question, does this new agreement require Senate advice and consent to ratification? Or might it be done as an executive agreement because the existing legal authority is sufficient? These memos are typically classified. They're not available to the public. I used to write them. So it is technically a technical exercise, at least in theory, but in practice, as you can see here, it can involve some judgment. So that's what's called the choice of instrument juncture, that big red dot. Okay, just to show you executive agreements in action in case we end up going that route. Here's one example, which is Japan whaling against American Cetacean Society. This is deals with both the public international level, the International Convention on the Regulation of Whaling, the Whaling Convention, which establishes a commission, which is a plenary body of the parties to establish quotas on takes. In this particular case, there was a zero quota on sperm whales from 1985 taken under the convention. Japan opted out of that. That's consistent with the structure of the convention. The idea is to create a specific juncture at which states need to repudiate the takes, the catch limitations if they choose to in a public way that can be examined transparently among the public. Now we switch to the domestic level. So Japan in this scenario was not in violation of international law by opting out of the zero take for sperm whales. However, domestic law actually is designed to create an incentive for states to comply with the convention in the first place by reducing foreign states' takes within the US EEZ, the US Exclusive Economic Zone, if they are undermining the effectiveness of the convention, diminishing the effectiveness of the convention. That's not the same as being in violation of international law. So what happened here? This is the crucial case in this field. Here's a picture of the IWC quota which had a hard edge at the end of 1984. And the United States government, the Reagan administration at the time, entered into an executive agreement which was designed to give Japan an extension, basically, so as to avoid the application of the domestic punishments, the domestic Pelly and Packwood amendments, through an extension of 1988. And the whale lovers, which I think I can describe as such because I am one, I'm not a member of this organization, but were concerned that was creating the wrong kind of incentive for Japan. And the government on the other side, the executive branch, the president, said, well, that is actually consistent with the intention of the domestic statute as well as the international agreement because it's creating an incentive for Japan to do something it otherwise would not do, which is to phase down its takes of sperm whales, even if on a somewhat more protracted basis. So that was the dispute in the Supreme Court. What the Supreme Court did was, I'm going to skip this one, but what the Supreme Court did was to basically harmonize the two and say, well, the executive agreement and the statute can be read together, so we will, and we'll put a thumb on the scale on the side of the government, and conclude that the two of them are mutually consistent with each other, even though there might be pretty good arguments that the executive agreement was contrary to the statutory purpose. Okay, the organizers asked me to address judicial review. This is the last bit of this presentation. The executive agreements can be reviewed. They are judicially reviewable like any act of the executive branch for the adequacy of their domestic legal authority. The question is, what's the standard of review? The answer is, now it's quite difficult to tell after recent Supreme Court jurisprudence. The one is West Virginia against EPA, which set aside the Obama Clean Power Plan, relying on the major questions doctrine. Another is Loper Bright Enterprises, also relentless, that overruled Chevron v. NRDC, and the deference that federal agencies were, the deference to agency interpretations of questions of law that were included in that case. In the interest of full disclosure, I am an alumnus of NRDC and actually was at NRDC at the time that case was decided. These relatively new developments have a dampening effect on the exercise of executive agreement power. That is, if the new instrument that Dr. Harrington was describing were to be done as an executive agreement. But there's another side to the question, which is substantial deference to the executive and the president in all foreign relations law. Famous article by Harold Honju Ko, the former legal advisor under the Obama administration, where the president almost always wins in foreign affairs. And let me tell you why. It's on this slide. The president is the commander-in-chief. He's the diplomat-in-chief. He or she is the commander-in-chief. He or she is the chief executive, and he or she is the diplomat-in-chief. There's lack of judicial expertise in areas that are literally beyond the water's edge. How can the judiciary opine on questions even as relatively straightforward as whale takes? I mean, the judiciary just doesn't have expertise. The president, he or she, does, and has brought that to bear in the executive agreement. Also, separation of powers, so as to avoid the appearance or the actuality of regulating or constraining the president's conduct of foreign affairs, which could have serious adverse consequences for the nation. And as a result, executive agreement continues in force as international law, even if the underlying authority is held to be lacking by a court. There are almost no cases in which that has happened. And you can imagine why. That judges lose a great deal of sleep over second-guessing the president and potentially throwing the United States out of compliance with international law while the agreement continues in force. The organizers also asked me briefly to touch on this, just to conclude. What other fora might this issue come up in? One is in Congress, in oversight. The Senate as an institution has no role in executive agreements. It tends to get cut out, as you can see, because it has no advice and consent role, and the House also out of implementing legislation. This is especially pronounced in situations of divided government. We saw this during the Paris Agreement, which creates an incentive for inter-branch, shall we say, tension between particularly between the Senate, but also the Congress as a whole, and the president on the other hand. And then last, the election is coming up. We don't know what that means for this area. So thank you very much for your patience, and I'll be glad to answer any questions about the domestic aspects of filling in the blanks on the new plastics instrument coming up. And many thanks to the individual who kept me on the straight and narrow with respect to the we may be looking at a female president in the very near future. So thank you for bringing that to my attention.
All right, I suppose I am the next speaker. So pleasure to be with you all today. My name is Dr. Jamal Ajin. I am a science and policy advisor at Break Free from Plastic US, and I'm going to talk about the stakes for the United States, both at home and abroad in this negotiation of the international legally binding instrument on plastic pollution. Okay, there we go. So I guess before I get into the legalese of it, I do want to first just take a step back and get a bit personal. So let's talk about all of the historic injustices that plastic and manufacturing and the plastic life cycle has been involved in. And that's pretty much every single one, as far as the breadth of history in the United States of America. Indigenous, frontline and fence line communities sustain harms across every stage of the plastic life cycle, from extraction to production to use to disposal, transport. Um, Here I have some pictures of Louisiana's Cancer Alley, which is a small stretch in Louisiana that has an overwhelmingly large concentration of petrochemicals, a petrochemical build out, and also pictured as ground zero in Port Arthur, Texas, where quite a few fossil fuel extraction facilities are located. And I don't have it pictured, but also affected is my hometown of Detroit, Michigan, where there is both a petrochemical refinery as well as where we incinerated our waste for quite a few decades, before activists and organizers mobilized to shut it down. So the Biden administration is technically under a legal mandate to do something about this via its overall legal mandate to foster environmental justice. And folks may know that that mandate includes executive orders that have been issued both during the Biden administration, such as Executive Order 14008 and 14096, which both directed all federal agencies to do a number of things around environmental justice, integrate them into their budgets and consider cumulative impacts in their directed rulemakings and so on. But that authority doesn't just exist under executive order. It also exists under legislative mandate through the mandates that have been supplied by packages that have been passed under the Biden administration, like the Inflation Reduction Act, which has a number of key EJ-related provisions, as well as through historic law, bedrock environmental law in the United States, such as the Toxic Substances Control Act, the Clean Water Act, the Clean Air Act, the National Environmental Policy Act. All of these pieces of legislation have in them a mandate to protect human health and the environment and consider the risks of toxic chemicals and so on. And this compels the Biden administration to act on plastic pollution in all of these various aspects. And some of this actually is quite robustly acknowledged in the Mobilizing Federal Action Report that Margaret mentioned at the outset, that does acknowledge in some places that, for example, the National Environmental Policy Act needs to be used to regulate plastic pollution and consider the impacts on communities of plastic production facilities. So, our authority to consider and to foster environmental justice is a significant and significantly underused authority, to David's points, when the United States is considering whether or not it can ultimately ratify this instrument. So I want to talk a little bit about the sort of geopolitical opportunities that there are here as well, because obviously, domestically, the real opportunity is to come through on our commitments to foster environmental justice and actually, win justice and equity in this country. But internationally, we have, as Margaret mentioned, and as I've kind of sketched out a little bit more explicitly here, quite a diverse landscape of countries that all have their sort of various interests in the Global Plastics Treaty. Some on the side of not wanting to see an instrument at all, and still others wanting to see a highly ambitious instrument and a highly effective instrument. And the U.S. is pretty squarely in the middle of those two groups, I would say. Even given our recent announcements on the proposed shift, there hasn't really been a submission of a conference room paper or a summary note or any sort of legal document outlining that shift. As of yet, the shift has only been really articulated by Undersecretary Fernandez at the recent General Assembly meeting. So for all intents and purposes, the U.S. position is still the position as described in the compilation text, and that still places us pretty firmly in the middle of this chessboard. But there is an opportunity for real leadership, and it actually kind of intersects a little bit with the opportunity for the United States to gain certain strategic advantages. And I think that may be part of the impetus that the State Department has had to make this shift that they are purporting to be making. So I want to talk a little bit about polypropylene in particular. Polypropylene is a primary plastic polymer. It's one of the fundamental building blocks of plastics. And in the US, we used to make polypropylene as a co-product that was emitted during the process of cracking ethane. And ethane is a feedstock for primary plastic polymers. So we were using ethane and cracking it to make ethylene and propylene. And we would just manufacture the propylene as a byproduct of all of that. But recently, more shale fracked gas has become available in the US. And with that increased availability of shale fracked gas, it's basically like an increased availability of a lighter feedstock that only now produces ethylene, but not the propylene co-product. And so that has drastically reduced the propylene supply in the US. And meanwhile, China is expected to lead in the growing propylene capacity in the world because they're producing propylene not as co-product, but via these on-purpose propylene production technologies. So in principle, in these negotiations, if the United States was to support a cap on primary plastic polymers, such as polypropylene, it could have significant geopolitical impacts because we're no longer really producing propylene and China is. But as I said before, we can't just lead on paper. I mean, it is a great thing that the undersecretary did signal openness to shifting their position on primary plastic polymers, potentially looking at chemicals of concern and a list of chemicals for annexation, and similarly a list of problematic and avoidable plastic products, and that this shift has been both kind of tertiarily present in the intersessional meeting and then announced explicitly at the General Assembly. But as of now, we've sort of only made that position shift in the realm of rhetoric, and that is kind of frustrating the member state-led process because a lot of member states are looking for how the U.S. is actually going to move when it comes to the compilation text, when it comes to the non-paper, and so they're very sort of cautious, and frankly, the feedback that we've gotten is cautiously pessimistic. That we're really going to see a shift from the U.S. especially with the elections looming, as David mentioned. And therefore, the best thing that the United States can possibly do right now is to do a submission of a summary note or a conference room paper or something to the United Nations Environment Program Intergovernmental Negotiating Committee's Plastic Secretariat, so that all of the countries have a tangible legal document in their hands stating that this is the position that the United States is going to take in Busan and beyond. And that could very much help to kind of break up the gridlock here and give people a lot more confidence in this shift. And I do want to talk a little bit about the non-paper with respect to the United States position as well, because as it is, the non-paper is of a significantly lower ambition than the announcement that was just made by Undersecretary Fernandez. And that I think creates an opportunity for the United States as well as the higher ambition countries that we know will take issue with the lowering of ambition that has happened via this non-paper, to be loud about that in Busan and to insist that the ambition of the compilation text be preserved both at INC 5 and beyond. So what do I mean when I say that it's significantly less ambitious? Well, I mean, actually, what I mean is that it seems as though the chair has taken implicitly some of the views that have been expressed by member states, such as the view that has been expressed by China on chemicals of concern and problematic and avoidable plastic products, and made it the sort of prescribed view for all member states in the non-paper. And I'll show you a little bit in the next slide what I mean more explicitly. But in principle, this does violate the member-led process, sort of presenting views that have been advanced by sort of specific countries as the basis of negotiations for all of the rest of the countries, is something that we can definitely expect that higher ambition members like Rwanda and Norway and Peru might take issue with in the opening plenary in Busan. And meanwhile, as Dr. Harrington pointed out, the compilation text is still what we have negotiated, is what we have agreed upon. It's what continues to have the highest ambition language in it. And so, it's definitely a curtailing of ambition for the chair to kind of try to roll this out and to make it the basis of negotiations. And we will see a lot of contentious discussion about this in a couple of weeks. And obviously one or the other will be the basis of negotiations moving forward. But we sincerely hope that the original ambition of the compilation text can somehow be preserved, and that the United States is instrumental in making sure of that. So just to kind of conclude, this is an example of how the non-paper is significantly less ambitious. We were originally talking about chemicals of concern for annexation, and then we were talking about problematic and avoidable plastic products for annexation, and sort of identifying criteria and non-criteria for listing them both, as Dr. Harrington said. And in this non-paper, we now see plastic products and chemicals of concern as used in plastic products. So you probably notice that the distinct category of chemicals of concern for annexation has been eliminated or kind of collapsed into this single category of chemicals of concern only as used in plastic products. And that, quite frankly, leaves out the frontline and fence line indigenous communities that I mentioned at the outset of my talk. because the chemicals of concern that are impacting the air and water supplies of our communities is not necessarily in the plastic product, it's in the manufacturing phase. And indeed, this production, this manufacturing phase is where the vast majority of these chemicals of concern are introduced, are, formed intentionally, unintentionally. But this non-paper has now, kind of significantly narrowed in scope with respect to that. And, we hope that U.S. leadership, apropos the announcements that were made by Undersecretary Fernandez, can be a way to ensure that, not only frontline and frontline and indigenous communities, but everyone that has been impacted by the plastic crisis can actually be protected by this instrument. Thank you very much, and I will yield my control back.
Thank you all so much. I just think it was a wonderful presentation and great to get the insight of all the different experts who have been deeply engaged in this process, but also have experience on different aspects of it that are, all being pulled together at the as these negotiations kind of speed towards a head. For the next about 25 minutes, we'll have an opportunity to answer some of the questions that were presented in the Q&A box. And then also, if panelists want to continue a discussion on a particular topic, we welcome that as well. So I'm going to start with the first question, and it's getting at the issue of how does a treaty like this work out in practice, and whether corporations or other entities can present legal challenges to stop aspects of provisions of a treaty from happening in the United States. It seems like a great thing on the outside that this could potentially stop aspects of production, et cetera. But can it actually, and how does it actually happen?
So I'm happy to jump in to address at least the first part of the question, and especially the part that's typed into the Q&A box. So with any treaty, it doesn't matter if it's an environmental treaty, human rights treaty, trade, anything. In international law, the parties that sign on are countries. So only countries will sign on. What it means when a country signs on is then that country is required to implement the treaty terms in its domestic law. However that might look, and it will vary by country, and it will vary by parliamentary system or regulatory system as well. But the only entities that sign on will be states. So I think that's the first really important thing to point out. The second thing then is the court system itself. So whether, for example, in the US, a corporation could challenge a provision of the plastics treaty when it comes into effect if the US signs onto it. That's very much a question of jurisdiction of each court system and how the interplay between the executive and the courts work depending on the country. So I'm sure that Dr. Worth, for example, will want to add a great deal more for that. But just to explain that at the international level, we're still very state focused, right? So only states matter in that one context. We all have very powerful voices in many other ways, but only states are parties.
Yes, David, please.
Yes, shall I pick? Thank you for the invitation from Dr. Harrington. And so just so I'm sure what question I'm answering, let me restate it. As I understood the question is how can a private party such as industry or an environmental organization influence through the legal process either the negotiation of the agreement, and its subsequent adoption, and then its implementation afterwards. Is that the question?
I believe so.
Okay.
Yes.
So during the negotiations, there's relatively little that private parties can do. In this strictly legal mode, they can become observers to the to the multilateral process. Many of those on this webinar are already accredited, including myself, directly to go and literally observe what is going on in Busan. But so there's an informal interaction between ourselves and our own governments, as well as other governments, as well as with the UN process, the Secretariat, with the chair, etc. But in terms of legal handles within the U.S. legal system, for those who might have standing within the U.S. legal system, very few. And the reason is that kind of challenge would be premature. It's what a lawyer would call lacking ripeness. So then the big juncture is when the agreement is made. That's the technical term found in the Constitution. And then there is something that private parties can look at, and there are obligations and rights that are contained in that instrument. So if it's then we get into the question of whether it's done as a Article 2, Section 2 treaty that still needs Senate advice and consent or ratification. Then the action would be with the Senate. It would probably be premature to challenge before that happens, right? Because we don't even know whether the Senate is going to give its advice and consent. And then after that, there could be, say, a constitutional challenge. Very, very, very rarely heard of, because the Senate's advice and consent basically it translates the agreement into domestic law along with implementing legislation. There may be some handles on implementing legislation in a legislative mode that private parties such as the American Cetacean Society, the whale lovers, or the plastics industry might be able to get a handle on there. As I suggested, if we end up in the executive agreement mode, obviously then the scope of the agreement is both extended to but constrained by the existing legal authorities. Again, that's the importance of the ELI report that we're here to talk about today, because it establishes both the scope, the breadth of the possibility in this executive agreement mode, but it also establishes constraints. And the law is pretty clear that all of those authorities need not have been already engaged. They just need to be potentially there. So that, excuse me, that's the Japan whaling case. That is reviewable, and a court would be obliged to give an answer to that question. That's where all the deference to the executive branch comes in. I see there's another question about what do you mean by deference to the executive branch? I'll be glad to answer that separately. But so yes, there would be an opportunity there to measure the executive agreement's content against the domestic legal authority, but those challenges have been the successful challenges along those lines have been extraordinarily few. And then at the third step, the implementation step, what's been described as the COP step, the conferences of the parties, which is post entry into force. Then we're talking about domestic implementation. Then we're talking about domestic and administrative law, environmental law. This is your usual Clean Air Act, Clean Water Act, Toxic Substances Control Act litigation. So the short answer is that for private parties, the handles on the negotiation process are very, very few. And the handles on the post-negotiation outcome they exist. We are a rule of law republic governed by a constitution. So every instrument such as this has to meet legal standards, but given the court's deference to the executive branch, very, very few handles on that. I hope that's responsive.
I think that was wonderful.
I'd like to add something here, just to say that I don't like the term industry, because there's a range of views in every group, and I will say that there's a number of businesses who are for global rules, and there are also there's a need for that for many reasons, having advised business to have rules of the road, but also that there's litigation that is going to occur in the absence of rules, toxic litigation, and so there's a safe harbor concern too. So I just want to say that nations will have to handle this either separately or together. And I understand people will have their opinions about how it should be done, and that will be worked out in the way that David spoke about. But I think pitting groups against each other in these conversations is probably not where this is going to be. This is more about what's feasible, what the time frame is, and what does science dictate needs to happen first. And that will out, whether it's in litigation or it's in the regulatory setting.
Yeah, and maybe if I could just add as well, I I do think that, certainly from a legal perspective, the levers that we have as UN accredited observers are very few. This is true. However, we have definitely found in these particular negotiations that making these things a political imperative for the member states engaged in negotiation has been really quite effective in shifting their positions. I mean, uh, as as uh, as I think a number of speakers outlined, the U.S. position now versus even where it was 1 year ago is drastically different. And we are also seeing drastic differences in the positions coming from China, coming from Canada, and these shifts have largely not been a product of the member interengagement process. It's been a product of the bilateral meetings that David mentioned that member states have had with us, really, as observers, in which we have, kind of talked about, especially what could be the political consequences of not giving us what we want. And that has, definitely proven to be effective in the realm of applying pressure. So, while it is true, we cannot, we are not the direct state actors. um, there's kind of a very effective inside and outside game that can be played with as observers, especially as observers that are coordinated from lots of different sectors like science and health and then civil society and so on, to influence the positions that are taken by member states. We're certainly not just neutral observers.
Thank you. And it's so wonderful to get all of the different perspectives on this and the different insight. Um, Following up with the next question, and Margaret and Jamila kind of led into this a bit. Since accurate science is so critical to the treaty, have the negotiators been receptive to scientists' input?
That's a great question. One of the challenges with this process is there's no formal place for science in the process. There's no coordinating mechanism to provide science to the negotiators. However, it sort of depends on the country's confidence in their own science mechanisms. For example, the United States relies almost exclusively on government scientists. And they, of course, are polite when you share your views with them, but they feel they've got a lot of information. Having said that, when we are able to submit a report like the Mindoro-Monaco Commission report on plastics in human health, I think that was very helpful because it was a synthesis. Similarly, large syntheses are usually helpful in general, and there have been a number of those syntheses reports that have been provided to everybody, and that the different negotiators have absorbed. On the other hand, there are many countries that don't have the advantages that many other northern hemisphere countries have. They have a lot of research institutions hungry for information. And so coalitions like the Scientist Coalition or the International Science Council, which I represent, they can provide that direct information. And there are regional groups, for example, the Africa group, the the group of Latin American and Caribbean countries, others who are really hungry for the information are grateful for it. But it is a shame that the process does not allow for that to be formalized. And so that's why many of us believe that the next phase will have to include that. And that is, I think, and I did hear a lot of countries say they cared about science. They're confused sometimes. It's very complex. And yet some people need it more than others and appreciate it. And there are many countries that are leading on the science, like Norway, investing a huge amount in this science, and other countries in the EU, which I'm envious of, in fact. Thanks for the question.
Yeah, maybe I could add a bit to that. Yeah, I definitely think that I agree with Margaret. I think that um, there are a number of countries that are really engaged in primarily science and also human health and human rights-based decision making. Rwanda and Norway being top of that list. Um, and then there are certainly other countries that are kind of only as interested in the science as it serves them. And I think that, a year ago, I would have put the US squarely in that category. I will wait until after Busan to tell you if they're still in that category. But a year ago, I would have put them, squarely in that category because they were talking about things like plastic circularity and kind of advancing this idea that we don't necessarily need to address plastic pollution at the production phase, at the extraction phase. We can simply design plastics to be more sustainable, which is, I mean, just absolutely contrary to every thing that the science of toxicity, as well as just the science of like environmental persistence and bioaccumulation has said. We've known for a long time that even mechanical recycling results in the proliferation of microplastics into our air and water, and certainly the false scientific solutions that are being presented in the negotiations for waste management, like chemical recycling, is literally in most instances, just straight up burning plastic into the open atmosphere. We've known for quite a while that there is no real circular solution for plastics, and bioplastics similarly is not the answer. But we did see the United States kind of promoting these ideas in the realm of product design, in the realm of waste management. And I think perhaps, with these recent announcements that have been made around really wanting to get serious about polymers, really wanting to get serious about chemicals, we will see something different. But I for one have seen a minority really of states very strictly adhering to the science and what it says, crafting policy solely based on that. I would say science has been, for the most part, invoked when it is convenient and ignored when it is not.
Does anyone else want to chime in? If not, I can move on to the next question. And thank you, Margaret and Jamala, for explaining that a bit further. So I think the next question might be a David Alex question. How does the dampening of executive agreements align with the Supreme Court's recent expansion of executive authority?
Shall I take that on as a first cut? All right. First of all, one has to be, again, one has to be clear about framing the question. So let me identify the question that I think is relevant to this particular situation, which is the executive's authority in the regulatory sphere. And so the questioner probably has in mind, for instance, the recent Supreme Court decision expanding the president's potential immunity for criminal liability for actions in office or not. We're not talking about that. We're talking about a particular subset of executive authority related to regulatory authority, related to plastics, related to the Clean Water Act, the Clean Air Act, the Toxic Substances Control Act. If you look at that subset, the Supreme Court's recent decisions, including the two that I mentioned, West Virginia against EPA, the Obama Clean Power Plan, as well as the relentless case and Loper Bright Industries, which reduce the amount of judicial deference to the executive. Both of those contract executive power in the regulatory space. I sometimes refer to this to my students as the other culture war you don't hear about every day, but you do hear about it in my class on environmental law and my class on administrative law. So that executive authority is I think most observers agree has contracted recently and is contracting. So if you start from the proposition that the president's regulatory authority extends only up to the existing instruments as set out in the ELI report, then that looks to be a contraction of authority for, say, an expansive executive agreement, an executive agreement that includes an aspirational, extensive interpretation of existing authority. So that's basically what I was pointing to. And what I was trying to do in the second slide was to say that, well, that's not the end of the story, because the president, as Harold Coe says, always gets a lot of deference from the courts in internet in foreign relations. And so there's something of a balance between the two. It's not one or the other. But as you can imagine, then a reasonable president would be careful if he or she were to push the boundaries. I mean, they've got to know what they're doing. And most presidents have been quite circumspect in doing that, particularly in situations of divided government and situations in which, as now, the law is changing. So I hope that's helpful.
And I think just obviously to echo everything that was said, and also just to point out that these are very important things to use as framing, even though it is a very American context of law and analysis. It's very important to think of this when we're thinking about framing and why certain negotiating positions may be taken by various countries, not only the US, but also other countries as well, countries facing elections, countries with very new regimes, et cetera. And it really, it does highlight that tension between this being a process to create a legal document that we will have as a legally binding document, but then it also being at the end of the day a very political and diplomatic process and a very political and diplomatic outcome that then will have to be implemented not only internationally but also nationally, and having to make sure that whatever is in these terms can not only be agreed to in Busan or wherever we may have the diplomatic conference, but also it can then be taken home and properly ratified and approved of by the countries that want to sign it, because this is another step that we haven't had the chance to talk about, and hopefully we will when we get to actually having a finalized treaty text. And that is the idea that, yes, we have a treaty text, this is wonderful, but we also have to have it ratified by the US, hopefully, as well as many other countries, so that it will then have legal effect and be binding and also have practical effect.
Thank you. I am aware that we're at time. Does anyone have any closing thoughts that they'd like to share? Otherwise, well, I'll give it a second. Any of those closing thoughts at this point? Otherwise, oh, Margaret, go ahead.
I would just say this could go on forever. I might suggest doing another one after the treaty meeting, because this is a complex process ahead for the United States. And I think that some of the materials that you're sharing today, these reports, will be helpful to those who haven't read them before. But they're many of us are entering this space with a lot of hope. And it was with gratitude for the chair trying to get this done. And I just want to say that while we all have our views on what should be in there, and we're very strong on them with science, I do think that this is a very incredibly important treaty to get done, or else we cannot start changing the trajectory of the incredible increase in plastic pollution in our environment. It's not getting better, and every day we wait, it's not going to help.
Thank you so much, Margaret. And thank you to Margaret, Jamala, David, and Alex for being here today and for sharing your insight and expertise. As Margaret said, this conversation could go on endlessly with these people here. And it's one of the highlights of my work of getting to speak with them as often as I do. So as we conclude, I just like to, well, does Madison want to give the concluding logistics?
Thank you so much to all of our expert speakers for joining us today. We appreciate each of you taking the time to speak on this panel and offer your perspective on these important issues. If you missed any part of today's program, you can find the recording and our speaker slides on the event page at eli.org. You can also find a link to the previous webinar we held on U.S. authorities to address plastic pollution, as well as a link to the report. With that, I will bring today's program to a close. Thank you again so much, everyone, and we hope you have a great day.